In this session, we will see about the rights of the mortgagor. Section 60 of the Transfer of Property Act deals with this. It gives what are the rights available to the mortgagor. Mortgage is one person is transferring the rights over the more property to another person, so that the other person keep that property as a security for the money. Once the money is paid, the other person, that is the mortgagee, is under an obligation to retransfer that. The section says that. We will see what are the rights. One is right of redemption. That is, the mortgagor has a right to get back his property charged to the other person. He has transferred some interest in the property to the other person for getting the money. Once the money is paid, he has to get back it. This is right of redemption. He has a right to take back the security. Second is, in case of need, he can ask the other person to retransfer the property to a third party. For example, it's an English mortgage, absolute transfer. He will be executing a deed, transferring all the rights over the property to other person. On payment of the money, he has to write another document transferring all the rights to the mortgagor. In this case, the mortgagor can request the other person to transfer it to a third party. So, retransfer in favor of third party, the mortgagor has a right to ask the mortgagee to retransfer the property in favor of a third party. This is second. Third, the mortgagor has the right for inspection and verification of documents. For example, a mango garden is given as possession to the other person. If he is not maintaining properly, if the plants are not properly watered, then there will be a damage to the asset, damage to the property. If the trees are not properly cured, carrying of the property is not done, then the value of the property will go down. Same way, if a house is given, if the house is not properly maintained, then the mortgagor has a right to inspect the property. If in the usufructuary mortgages, the income and the rent received from the property can be adjusted towards the interest, then the mortgagor has a right to see whether it has been properly accounted. The fourth right is right of accession. That is already when we were seeing about the usufructuary mortgage, we have seen this. That is, when there is accession to the property, the mortgagor has to get back the property along with the accession to the property also. Next is, in case of lease, the mortgage, the owner has a right to give the property on lease also. For example, if it is a simple mortgage, only he is creating a charge. In case I am not paying the money, you go to the court and take the security. In that case, the mortgage property can be given as a lease also. Now we will see in detail about section 60, what the section 60 says. Section 60 says, anytime after the principal money has become due, the mortgagor has a right on payment or tender or proper time and place the mortgage money to request the mortgagee. That is, he has to pay the money after the money is due at the proper place. Then he can request the mortgagee to deliver the mortgagor that mortgage deed. He has executed some deed, creating a charge over the assets. Then he can ask him to deliver the mortgage deeds along with all other documents. For example, in the case of mortgage by deposit of title deeds, all the title deeds are given to the creditor. Then on payment, the creditor has to return back all the title deeds. If there is a mortgage is registered, then the other person has to retransfer the property again by executing a deed and also by registering. This is the number one. Number 2, if possession is given, the mortgagor can ask the person to give back the possession. For example, in the case of usufructuary mortgage, possession is given. So, on payment of money, the mortgagee has to give back possession to mortgagor. Fourth, at the cost of mortgagor, anything if it is required, he has to retransfer by document and the expenses to be borne by the mortgagor. For example, in the case of English mortgage, absolute right is transferred. On payment of money, the mortgagor has to return back the same thing. He has to retransfer the interest by executing another deed. For that, the mortgagor has to bear the expenses. Mortgagee is under an obligation to retransfer the assets. These are the rights given. And these rights are subject to a condition. It is not because provided that the right conferred has not been extinguished by the act of parties or by degree of court. If there is a degree of court, then the mortgagor has no right to take the possession or ask the mortgagee to retransfer the interest in the property. If there is a degree by the court, intervention of degree, if a court is there, by the act of the court, this right is lost. Another one by the act of the person itself. For example, the mortgagor himself is selling the property to the mortgagee, then the right is not there. One more thing, the section says the mortgagor can pay the money after it is due. So, one time is fixed, the mortgagor can exercise his right of redemption after making a payment after the time is there. For example, the mortgage is for 5 years. The mortgagor has the right of redemption after 5 years by making the payment of the mortgage money. If no time is fixed, for example, usufructuary mortgage, there is no time. If no time is there, then after giving a reasonable notice, the mortgagor can make a payment of that mortgage money and ask for the possession, ask for the other person to retransfer the right over the assets. Now, another thing. The mortgagor is giving up his rights to the other person to secure the debt. He gives the property as a security. But it should not be made as a sale. The person who is in need of money will be agreeing to any condition put by the mortgagee. So, the condition should not be onerous. Then it will be against the natural justice. For example, if the person is writing, the mortgagee is giving the mortgage, writing in the mortgage deed, if you are not returning back the money by 5 years, the property is mine. This is not possible because there is a maxim that once a mortgage, always a mortgage. There was a case, Noakes and Company versus Rice. This concept of once a mortgage, always a mortgage came in that case. Now we will see what are the things coming under clock on registration. For example, if the mortgage period is unreasonably long. For example, the person is writing a mortgage deed, I am giving you the money, you repay after 200 years. Then it is a unreasonable thing. It is a clog on mortgage redemption. That is, the person is restricted from redeeming his property. In this case, Fateh Muhammad Khan versus Ram Dayal. The mortgage was for 200 years. This was held to be a clause on redemption, not valid. It is a void condition. Another case, Masa Singh versus Gopal Singh. Here the mortgage was for 90 years. That means this person cannot see the property in his lifetime. It is unreasonable. So this was also held to be a clause on redemption. The term was void. Then condition of sale in default. That is, in case if you are not remitting the money, the property is mine. I will treat it as a sale. Then that also called as a clause on redemption. It is a restriction on redemption. That condition is not valid. Another one, third, restraint on alienation. That is putting a condition that you should not transfer the property to anybody. This is also not valid. It is a void condition. For example, if that person has borrowed money of 10 lakh, now he is in urgent need of further money, then he can sell the property. That restriction on alienation, that you should not transfer the property, you should not sell the property, you should not give the property as a gift. These all things are restriction on redemption. That is not void. That is not valid. Now, fourth, collateral benefit to the mortgagees. The mortgagees should not take any collateral benefit. He has advanced money. At the most, he can take the interest on the money advance. He cannot take anything beyond that. If there is any condition beyond that, then that condition is void. This has happened in the case of Knox and Company versus Rice. Rice is a person, he was a dealer. He mortgaged his premises and also goodwill to Knox and Company. Knox and Company put a condition that the Rice, in case he is doing any business, he should source the goods only from him. It was a malted whiskey, that is malted liquors. He should source the supply only from the person, mortgagee. This case went to the court. Court held this is not valid. Only in this case the concept of once a mortgage, always a mortgage came. Because this person is putting an unreasonable condition of the person to source all his supplies from this company. Next is condition of postponing redemption in case of default. This was also another case. The original period was 5 years. If you are not redeeming the property, if the redemption of mortgage is not done by the end of the 5th year, you cannot come with the payment for the next 12 years. You can come only after 12 years. That is, once the redemption is not done on 5th year, you have to redeem it only at the 17th year. This was also held to be unreasonable condition as void. Another condition, postponement of redemption by subsequent agreement. A person might have mortgaged money, mortgaged the property. There may be another agreement, so the first mortgage should not be redeemed. Redemption should not be there for the first agreement. For example, a bank may give a loan. Again, they may give a loan on another occasion. They may enter into agreement, the second agreement, saying that the first mortgage should not be redeemed within the when the second loan is there. That type of condition is valid. Then right of preemption. Preemption means the right of purchase, right to purchase. That is, in case of sale, you should come to me, get my concurrence that I am going to buy or not. First option to buy should be mine. This is preemption. The mortgaged property, if the mortgager is going to sell the property, he has to go to the mortgagee. Are you going to buy? Then if the person is saying yes, it should be sold only to that person. That is right of preemption. That right of preemption is not valid. It is a void. If there is any mortgage containing a right of preemption, that condition is void. the redemption and the foreclosure are coextensive. So long as this person has not paid the money, the other person, that mortgagee, has a right to proceed against the property for foreclosure. He can go to the court, get the degree for selling the property. This person has a right of redemption. These both are going together. This right will be there till the sale is registered. For example, if the person has not paid the money after 5 years, what the other person will say? He will go to the court. Court will order sale. Till the order is confirmed, this mortgagor has a right of redemption. He can go to the court before the sale is confirmed by the court. This is my money. This is other expenses for the other party. You take this and give back the money to me. In the case of LK Trust versus EDC, there was a sale of the mortgaged property. The offer was accepted, but no sale was executed. No sale deed was executed. At that time, this person, mortgagor, went, the court held the mortgagor as a right of redemption. Till the sale is confirmed, the mortgagor has a right of redemption. In Sri Jayalakshmi Textiles versus International Asset Reconstruction Company Private Limited, in this case, the sale certificate was issued, sale was completed, then it was held that mortgagor has no right to redeem the property. No right of redemption is lost once the sale is confirmed. In the second part, we will see the remaining rights of the mortgagor.